And if you thought the headlines on November 5th put an end to your nightmares of the Supreme Court snatching this victory away from the Democrats, too, how do I put this? This is the case of D'Onofrio v. Wells, which tomorrow the Supreme Court will decide whether or not to even entertain. D'Onofrio is Leo D'Onofrio, who sued New Jersey's Secretary of State Nina Wells to block Barack Obama's name from the Jersey ballot because he thinks Obama is not a natural-born citizen of the United States, therefore constitutionally barred from serving as president. Yes, this crap again. When a lower court declined to hear D'Onofrio, he went to Justice David Souter, who did likewise. On November 14th, D'Onofrio applied for an emergency stay, asking the High Court to delay the December 15th meeting of the Electoral College. This time he asked Justice Clarence Thomas. On November 19th, Thomas scheduled the case for the full court's conference tomorrow, a conference at which the judges will decide whether or not to hear D'Onofrio's request. Let's turn now to George Washington University constitutional law scholar Jonathan Turley about this one. John, good evening.
Hi, Keith.
All right, can we set those nightmares to rest? This is not Bush v. Gore again?
It's not Bush v. Gore, and the odds are heavily against this petition. I think, frankly, some of the judges would prefer to drink molten lead than to get involved in another election, because they're still smarting over the whole Bush v. Gore business. They're still being asked, every time one of these guys gives a speech, people ask about it. And so my guess is that whatever interest there is by Clarence Thomas is probably not going to be shared by many other justices.
Hawaii officials have said the original Obama birth certificate is valid and is in their vaults. The thing was shown to the independent outfit, Brooks Jackson's outfit, factcheck.org. People at the really far right website, WorldNet Daily, even say they saw it and it's legit. What exactly is the D'Onofrio claim here? Do you know?
Well, this is a little different from many of these other lawsuits. Many of the lawsuits claim that he cannot be eligible for president because he was born in another country. Some say Indonesia, some say Kenya, even Canada. But this one says something different. This one says that because his father was an English citizen, that he had dual citizenship, and that makes him ineligible. But it's the type of argument that, frankly, is not going to appeal to the justices. It has never been under review by the Supreme Court. And I don't think that they're going to find that this is a case with the standing or the substance to grant review. It's not saying anything about the merits, but there is a political aspect about these types of filings. And judges and justices are loath to get involved in these types of challenges before an inauguration.
So when the Supreme Court refuses to hear this and the people living in denial over the election try to keep it going, I mean, we addressed this in 2004 when some of Mr. Bush's state victories looked a little dubious, at least. Once a president is sworn in, that's it, right? There's no overturning of elections, whether for some legitimate reason or, you know, bogus claims of insufficient citizenship.
Well, it would be very hard to make that cat walk backwards. We've never seen a case where an inauguration was obviously undone. So the eligibility question here is likely to fall to the wayside. And of course, this was inevitable because John McCain had his own eligibility question. Of course, there also remains Hillary Clinton, who has her own eligibility question.
Well, that's not a citizenship one. That's a question of a raise for Secretary of State during her tenure in the Senate. Now, all right, now explain your position on it and why it matters, actually.
Well, the problem is that the Constitution is quite clear. You cannot assume an office that you voted to give a pay raise for. It's part of the anti-corruption, anti-conflict of interest aspects of the Constitution. She did vote for a bill that created the mechanism for automatic raises. So a vote of hers did cause an increase in the salary of the Secretary of State. Now, what is being discussed is doing a sort of Saxby fix. This is the guy who was Attorney General under Nixon, where they went back and just reduced the salary of the Attorney General and said, look, it really wasn't raised. At least it's not there anymore. Many people feel that that really didn't solve the problem. It was just never challenged. My guess is that she will be the next Secretary of State. But I must confess to you, I think that this is a serious constitutional question. I think that there is doubt as to whether she qualifies because of that, I admit, rather arcane provision.
the raise was like less than $10,000. Is there not some other solution to this? Do we not need to, in this day of with millions upon millions in politics, don't we need to somehow change the Constitution so we don't have these things coming up for $10,000?
I'm pretty sure she's willing to give up that money, although it would raise an interesting pay parity conflict that she'd be paid less than men in the cabinet, but I think she'd live with that.
And somebody can write a book about it and make her all the money that needs to be made in the difference. Jonathan Turley of George Washington University, as always, great thanks, John.
Thank you, Keith.